The Supreme Court of India today heard a batch of petitions challenging the anonymous electoral bond scheme after a long hiatus. The case was listed today for the first time after its last listing back in March 26th last year. During the last held hearing of the case back in March 2021, a bench led by then Chief Justice of India S.A. Bobde had refused to stay the electoral bond scheme ahead of assembly elections in 5 states by observing that there are sufficient safeguards in this scheme. The bench had also observed back then that the scheme had been introduced to ensure that political donations happen through banking channels. With regards to the concerns about donor anonymity, the bench had said that it could be pierced by culling out information from the records filed before public authorities and by doing match the following. The petitions challenging the electoral bond scheme was never listed during the term of the former Chief Justice of India N.V. Ramana, despite urgent mentioning made by the petitioners. Although the then CJI N.V. Ramana had agreed on April 5th this year to urgently hear this particular case pursuant to a request made by Advocate Prashant Bhushan, the matter did not get listed during his tenure. A bench comprising Justices B.R. Gavai and B.V. Nagarathna today posted the batch of petitions challenging the electoral bond scheme for further hearing on December 6th this year. Essentially, these petitions were filed in the Supreme Court back in 2017, challenging the provisions of the Finance Act of 2017, which had paved the way for anonymous electoral bonds. The Finance Act of 2017 had introduced amendments in a host of legislations such as the Reserve Bank of India Act, Companies Act, Income Tax Act, Representation of Peoples Act and the Foreign Contributions Regulation Act to make way for electoral bonds. The petitions have been filed by political party Communist Party of India, Marxist and NGOs Common Cause and Association for Democratic Reforms and challenge this particular scheme for being an obscure funding system which is unchecked by any authority. For a bit of context, the electoral bond scheme was introduced by the BJP government and the central idea behind introduction of such a scheme was to bring about transparency in electoral funding in India. In the Union Budget speech on February 1st, 2017, the then Finance Minister Arun Jaitley had underscored that political parties continue to receive most of their funds through anonymous donations which are shown in cash and that there was a need to cleanse the system of political funding in India. As a result, Jaitley had proposed 2 main changes. 1. He had reduced the amount of money that a political party could accept in cash from anonymous sources from 20,000 to 2,000 and 2. He had announced the introduction of electoral bonds as a way to make such funding transparent. The electoral bond scheme was formally introduced back in 2018. To know more about what exactly is an electoral bond and why is it so controversial, you can refer to our earlier video where we have explained this in detail, the link to which has been given in the description box below. In the brief hearing held today before the Supreme Court, senior advocates Kapil Sibal, Gopal Shankar Narayan and Advocate Prashant Bhushan appearing for the petitioners pressed for an early hearing of the matter either next week or in November ahead of the assembly elections of Gujarat and Himachal Pradesh which are likely to be held in December. Attorney General for India R. Venkataramani and Solicitor General of India Tushar Mehta submitted today before the Supreme Court that several Constitution Bench hearings are scheduled in November and thus requested that the present matter be posted to January next year instead. The petitioners objected to this request and urged for an early listing. Ultimately, the bench agreed to list the matter on December 6th this year. At the outset of the hearing today, Advocate Prashant Bhushan submitted that 3 interconnected issues arise in this case. 1 is the electoral bonds issue. Next is whether political parties can come under the Right to Information Act. And third, whether the retrospective amendment to the Foreign Contribution Regulation Act, that is the FCRA, is legal. By virtue of this amendment, Bhushan said that anybody can get foreign money. Whether these changes could be introduced through a money bill is yet another issue, Bhushan added today. Senior advocate Kapil Sibal further contended today before the Supreme Court that the issues are important and hence the matter should be heard by a larger bench instead. The bench then wondered if a reference can be made without finding any conflict with any other judgment. Sibal then referred to Article 145 of the Constitution to say that constitutionally important matters are to be heard by the Constitution benches only. Solicitor General Tushar Mehta, on the other hand, said that the scheme has ensured transparency by eliminating black money from political funding. He argued during the hearing today, and I quote here, "The methodology of receiving the money has been so transparent. We will take your lordships through step by step. Now it's impossible to get any black or unaccounted money. Very transparent system. To say that this affects democracy may not hold the water." At this point, Justice Gavai asked, and I quote again, "Does system provide for where the money comes from?" The Solicitor General responded in the affirmative today. The Supreme Court bench also asked the Attorney General about his view regarding the proposed reference to a larger bench. The Attorney General replied that there should be a threshold hearing by the bench before deciding on the proposed reference. Bhushan also informed the Supreme Court today that the Election Commission will announce the election schedule for Gujarat and Himachal Pradesh today, and added that electoral bonds are issued before every elections. Solicitor General Tushar Mehta at this point said that this is, however, not an election-related issue. The bench at the end of the hearing ultimately posted the matter to December 6th. When Sibal sought for an earlier posting, Justice Gavai said that the matter has been pending for the last 7 years in any case. Thank you. I'm Nagarathna for LiveLaw. Keep watching LiveLaw for more such updates.